OCO, and welcome to the Cherokee Phoenix Breakdown. I am Tyler Thomas, the executive editor of the Cherokee Phoenix, and I am honored to be joined by Cherokee Nation Principal Chief Chuck Hoskin Jr. In this episode, I will discuss with Chief Hoskin the recent U.S. Supreme Court Haaland v. Brackeen ruling and its impact on Indian country. The Haaland v. Brackeen case was focused on the Indian Child Welfare Act and challenged whether the nearly 50-year-old law was constitutional or not. On June 15th, the court rejected the challenge to ICWA with a 7-2 ruling that was celebrated throughout Indian country. Chief Hoskin, thank you for joining me today.
Well, thanks for having me and covering this really important topic.
All right, Chief, we'll jump right into it. Before we discuss the actual ruling, can you give me a synopsis of what this case really entailed?
Well, this case was a challenge to the Indian Child Welfare Act, and a lot of people have heard about ICWA, the Indian Child Welfare Act, but just by way of background, Tyler, in 1978, the Congress enacted this law, and the Congress held hearings, did studies, and reached some really troubling conclusions about the welfare of Indian children in this country, specifically that for the century before 1978, the United States, through its policies and through similar policies at the state level, had really damaged the well-being of Native children and families. And this took many different forms. Boarding schools, which people are familiar with, was part of a federal Indian policy that was bent on removing tribal children from their lands, from their families, taking them to boarding school to supposedly civilize them. You know, the troubling old saying from the 19th century was kill the Indian, save the man. In other words, destroy those cultural ties and life ways to somehow civilize or save the individual. There were also pressures from state child welfare agencies. As people understand, the United States grew, and states like Oklahoma were imposed over tribal lands. So were new norms and customs. So you have child welfare agencies intervening in what are traditional ways of bringing up children on tribal lands, and those child welfare agencies determining that what was really customary traditions of extended family caring was somehow abusive to children, and those children were displaced in that way. And then, Tyler, you have an adoption industry which continues on, but for really now into a couple of centuries has been profiting off removing children from tribal lands. You can see some really disturbing newspaper ads from the late 19th century essentially selling Indian children, and that's really the industry that today is in a different form, but is still, I think, profiting off the idea that if children are removed, they can be somehow saved. So all of that is what Congress looked at. They looked at the fact that a substantial percentage of children in tribal nations were displaced from their tribal lands and taken off their tribal lands and put into the hands of non-Indian families. All of that caused Congress to pass ICWA. And I can break ICWA down very simply. It basically says that the child has a right in court as a citizen of an Indian nation. In other words, the United States and the states ought to respect the fact that this child is a citizen of an Indian nation, and that ought to mean something in this country. It sure should mean something in this country. And the child's tribe ought to also have a place in that courtroom. All of those interests are alongside all of the other interests that we think about when we're talking about a placement proceeding in which a child is being adopted or fostered to another family. Often these cases are in the context of investigations of abuse or neglect. And so the best interest of the child is really, really important. And so what ICWA says is all of those interests have a say in whether the child and where the child is placed and whether she is placed. And so there's also priorities. And so the judge at the district court level has to make it a priority to keep the child in the extended tribal family or within the tribal community. And then the last preference within tribal lands is even an adjacent tribal community. That's actually very rare. And then lastly, they could be adopted or fostered or temporarily placed in the custody of a non-Indian family. Here's what's really important. ICWA doesn't dictate that the child, under every circumstance, stay with a tribal family or tribal lands. It's just part of the analysis. And so the attack on ICWA took a couple of forms, and this was funded by interests that really want to destroy tribal sovereignty. And what they said was This is a racial preference. Forget that tribes are political entities and sovereign nations, and that citizens hold a political status. This is all about race, and so the Equal Protection Clause of the Constitution ought to wipe ICWA off the books. The other arguments they made were more along the lines of states' rights. In other words, states have a right to determine how child proceedings occur and what interests are involved in court, and the federal government ought to stay out of it, and that they don't have the authority in terms of regulating the affairs of Indian tribes to have a place in state court. So those were the basic arguments. Those arguments were largely dismissed by the court, not entirely though, and I know we'll get into what might come next.
What was the Cherokee Nation's role in this case, and when did it become a participant, or how did it become a participant?
We became a participant as the case was going to the Circuit Court of Appeals. And so the case originates in where all these cases originate, which is in a state courtroom, a district courtroom, your county courthouse in the state of Texas. It works its way up to the federal district court, and the folks attacking ICWA, including the family wanting to adopt the Indian child, sought relief in federal court. As it's going to the Fifth Circuit Court of Appeals in Louisiana, a number of tribes got together, not only the Cherokee Nation, but another number of tribes got together, pooled our resources, and just as important, our talent, a lot of talented lawyers on this case, to weigh in on behalf of the kids in this case, and more broadly, the Indian Child Welfare Act, because it was under attack. The case at the Fifth Circuit was a mix of a win and a loss in terms of the analysis, and then we stayed hooked up to the Supreme Court.
Why was it important for the Cherokee Nation to be an active participant?
Well, these cases that you can imagine are about issues that are bigger and historic and further reaching than the confines of the case itself. But this really bears remarking upon. Every one of these ICWA cases involve a child, and they all involve families, and they all involve adults who, I think, at the front lines of these cases, they really do care about the kids. They absolutely do. We always have to remember that there's really well-meaning people wanting to make a kid's life better, safer, and all of those important things. But this case, of course, was commandeered a bit by the anti-tribal sovereignty forces that we've seen time and time again. So that's the reason Cherokee Nation got involved. If ICWA was struck down, it would do harm to the Cherokee Nation. It would do harm to all of Indian country, but we have a really robust Indian Child Welfare Department. It's just in our interest to look out for the fate or to try to control the fate, so to speak, of this important federal law. So we had to be involved. And of course, anytime you're talking about an attack on a statute that's supposed to bring justice and fairness and secure tribal sovereignty, we know that a loss there could have a ripple effect across other statutes that are important. So all sorts of reasons for Cherokee Nation to use its resources and its talent to be involved in this case.
As I stated a minute ago, the court rejected that challenge to ICWA with a 7-2 ruling. In your opinion, what does that rejection to the challenge mean for the Cherokee Nation and really all of Indian country?
Well, it's a vindication for Indian kids, first and foremost. I mean, we always have to remember that the rights of Native peoples as citizens of their respective nations was really what was at stake here. And we're talking about the rights of our youngest citizens across Indian country. So it was a vindication for those rights. It was also a vindication for the broader idea that the Congress and the federal government has this supreme role. The states are subordinate in terms of the United States supreme role in regulating the affairs of Indian country, and that the Congress had the authority to recognize that tribal sovereignty and tribal governments have a place in the courtroom alongside those, again, youngest of tribal citizens. This is really important because if it goes the other way, then suddenly a district court case in which one of our most precious resources, our children, where their welfare is at stake. Can you imagine living in a country where the tribe is excluded, has absolutely no place in that? I mean, my goodness, what kind of tribal sovereignty is it if it cannot be used to protect and look out for the welfare of children? And so that's what was at stake. And so that idea that tribal governments and tribal citizens as citizens have a place in that courtroom, that was vindicated by a vote of 7-2. That's really powerful. You know, Tyler, we've seen a lot of cases that have been really close, not only Indian country cases, but a lot of cases that are very much in the news, 5-4 decisions. This was 7-2, and it was a mix of justices that you would look at and say, well, there's some conservative and liberal justices on the same side.
Yeah.
I think that's really important.
Yeah, and that brings me to my next question. Did anything about the rulings or opinions of the justices surprise you? Who ruled in favor, who ruled against, anything like that?
Well, Justice Barrett, the newest justice, she sided with the tribes, and I was present as just an audience member there for moral support during oral arguments, and some of the questions she asked really led me to think that she was going to vote against ICWA. She also has a background that would be suggestive of at least being a little dubious of ICWA, but she sided with with our side, with Indian country. That's important because she was one of the votes that helped erode the McGirt case. We're not talking about McGirt here, but you and I talked before about McGirt, that really important historic 2020 case that restored the reservations of several tribes. We know a few years later in the Castro Huerta case, she was on the side of eroding some of those gains. And then we have Brackeen, where I was braced and many were braced for her to be on the other side. She sided with the tribes. And I think it shows you that the justices are learning and evolving. I think that's true and hope it's true. Also shows you that Indian country cases are not a monolith. They're all very unique in terms of the statutes involved, the constitutional provisions involved, and the facts of the case. The other thing that wasn't too surprising, but I would encourage our listeners to take a look at, was the decision written by Justice Gorsuch. He's the same lead justice on the McGirt case, and his writing when it comes to tribal sovereignty, Tyler, it's almost poetry in terms of its beauty. And it's something that I think young people in particular should read, and they should draw some hope and inspiration that there is a champion on the court for Indian country. Now, it wasn't all, of course, a complete win. Even though it was a complete win on ICWA, there are things in that decision, Tyler, that ought to at least give us some reason to brace for what's next. And I know we'll talk a little bit about that.
This case's impact extends beyond ICWA. It has ramifications on tribal sovereignty. Can you elaborate more on how this did affect tribal sovereignty?
Well, in a couple of ways. One is validating tribal sovereignty in the context of family law is really important. It can come up in other contexts. The idea that that the federal government requiring states to do certain things to achieve some justice for Indian country, that was attacked as commandeering. And this is the idea that the federal government shouldn't be able to come in and just tell a judge what to do or to tell a state official what to do. That was dismissed, and that's important because there could be future cases in which federal Indian policy presses upon a state official, and the state official ought to have to carry out those actions. This case at least supports that idea. But Tyler, here's another area where it has far-reaching effects for what the case did not resolve. The case did not resolve this equal protection argument. I mentioned at the top of the podcast that one of the attacks on ICWA is that it is a racial preference. The court didn't determine that issue, and the reason the court didn't determine that issue is it said that the state of Texas, which had challenged ICWA, we should have mentioned that, I should have mentioned that, the state of Texas challenged ICWA. It said the state of Texas didn't have standing to say that the Equal Protection Clause was violated because it's a state, not a person. So that means that that equal protection issue wasn't resolved. And some of the other opinions in the case suggest that, boy, it sure could go against the tribes. That is so important, Tyler, because so much of the foundation of federal Indian law rests upon this idea that's been around for centuries, which is that tribes are sovereign Indian nations, and that you and I, Tyler, as citizens of the Cherokee Nation, hold a political status, not a racial classification. Certainly, we can probably all be classified by race, but in terms of our legal rights, it's our political status as citizens of the Cherokee Nation or all the other tribal nations and citizens around the country that they're affiliated with, that's a special status. We get attacked time and time again on all sorts of different statutes for being racial preferences. People have watched the news lately about affirmative action, for example. We know that the BIA and the Indian Health Service can exercise a preference, notwithstanding the affirmative action case, for citizens of Indian nations because of that political status. Right now, there's a challenge, Tyler, in federal court against the National Indian Gaming Regulatory Act. That is the law that is the foundation for Indian gaming across the country. Guess who's involved in attacking that law? The same interests that attacked the Indian Child Welfare Act. And the reason the same interests are attacking both of these cases is I don't think they're so concerned about Indian children. And I don't think they're so concerned about the millions of dollars of revenue, really billions of dollars of revenue that tribes see and share with states. I think they're concerned with destroying tribal sovereignty. And so this idea that it's still ripe for attack, the idea that this is an equal protection situation, that this is a racial preference, that's troublesome. It's worrisome to me. And I think everybody across Indian country needs to celebrate this Brackeen case, but we need to, as we always have to be, Tyler, braced for that next attack. And I'm afraid that next attack is going to come in the form of an attack on some law protecting Native Americans being a racial preference. We've got to push back on that.
Yeah, in regards to that challenge or that next attack, what's Cherokee Nation doing right now to prepare for it?
Well, we'll be prepared to weigh in on any case, and that includes the way we did in ICWA. You know, we went to the appellate court and filed a amicus brief, and we had a lot of talented lawyers. Typically, we're waiting for a case to get to that forum so we can have the best strategy. And I think we should follow the strategy we followed in Brackeen, which is we understand that as strong as Cherokee Nation is, and we've got great lawyers in our Attorney General's office and our outside counsel, we really work best when we work as a coalition. And so I can imagine the next time we do this, it'll be on a basis of a coalition. So we're watching. We've got really good people analyzing the cases. That particular case I mentioned, challenging Indian gaming, still working its way up. We'll have to make a strategic decision about how we weigh in. But we're at a point now at Cherokee Nation where we've got eyes all over the country watching for that next case and deciding when best to weigh in.
This is a kind of off the path question, but what kind of role could a seated delegate in Congress have in these kind of scenarios or situations?
Well, that would be a very powerful position for Indian country if we had, and we're talking about Cherokee Nation's right to a delegate in the Congress.
Yes.
Here's what we were prepared to do, Tyler, had the Supreme Court, as many of us were worried, found ICWA to be unconstitutional. We were going to go straight to the Congress and work on some sort of fix to save as much of the Indian Child Welfare Act as we could, because I mentioned it before, but ICWA is about protecting that most precious resource for a tribe, which is the next generation, and not have that generation robbed from us. So you can imagine having a delegate to Congress who understands ICWA, understands the court decision, and understands the role that Congress can play to mitigate the damage of a decision like that. So that would be powerful. Without the delegate, we're left with where we always are, which is acting outside of the Congress, advocating to the members of Congress. Imagine having somebody on the inside that could work in favor of Indian country. That would be power. That's why we're working to get Kim Teehee seated.
Yeah, and then my final question is, what kind of role or how important is it that a citizen of a federally recognized tribe is a Secretary of Interior and going to bat for tribes specifically in this case?
Well, that's also really about power and influence. And I mean that in the best way. I mean, people talk about power and influence in DC, and sometimes it brings up really bad feelings about lobbyists and things of that nature. When you can use power and influence to protect Native peoples who've been suppressed and oppressed for generations. That's my kind of power. That's my kind of influence, Tyler. And so having a Secretary of Interior that understands those issues is important. So let's take the boarding school issue. It wasn't until Secretary Deb Haaland, the first Native American woman to ever hold that seat, first Native American to hold that seat, I believe. It wasn't until she occupied the position of Secretary of Interior and was dedicated to examining the hard truths for this country of its boarding school policy and the deaths that occurred as a result, and the suppression that meant, and the dispossession of cultural lifeways. Wasn't until she said that was important that it becomes part of the national consciousness now, and I think it is. And so we've got policymakers with deeper knowledge about this subject. We've got the country talking about boarding schools. And so that's one example, Tyler, of how someone in that office can raise an issue that I think will have a generational effect in the positive. I could go up and down the list, but there are sacred sites in federal public lands that the previous administration had delisted. In other words, they opened it up for open season on some sacred sites that other tribes had in their cultural traditions. She's restored those, and I think she did it because she gets it, she understands it. And so if people want to know whether elections matter, whether getting Native Americans in a position to occupy these positions, hey, that's Exhibit A, Tyler, right there.
Yeah. Chief, you have any final remarks or anything regarding Brackeen or anything that we've discussed today?
Well, the only other thing I would share with you, Tyler, is that even though this case was decided in courtrooms, I mean, look, I'm chief of the Cherokee Nation, but it was out of my hands. All I could do is be providing moral support to this team of great lawyers. But I still think this is an issue where knowledge is power. And so the more Native Americans that understand the Brackeen case, that understand ICWA, and let's face it, we need more than just members of federally recognized tribes. We need the whole country to understand this. So the more we talk about these cases, and this is a great forum to do it, I think the more powerful we are. Because if we don't have knowledge, if we're collectively ignorant of things like ICWA, well, it can be taken away. We can't let that happen. So we've got to keep talking to each other about it and educating each other.
Well, Chief, I appreciate you joining me today and discussing this topic and giving us some of your time.
Well, no, Tyler.